We can hear music.
Yeah, that's coming from our television room.
Ah, okay.
All right, so we're going to go through week 7 now, and we're going to have a look at this. We're effectively taking a further step in terms of this idea of intrinsic material, and we're just delving a little bit further. You'll remember last week we started to look within an act at things like the headings and the objects clause and some of the things within an act to help us in terms of interpretation. And you'll see that the readings this week, they look at the different way we can interpret different individual words and how courts have used the interpretation of individual words to help us determine, obviously, the meaning of an act, the meaning of a statute, the meaning that the legislature intends us to use. We'll start to look at this idea of ordinary meaning. Ordinary meaning, whenever in the past, I recall phrases like literal meaning and plain meaning. So ordinary meaning for me is quite a new phrase in the sense that certainly in the past I recall plain meaning or literal meaning being, and that is you read the act and you work out just by the words therein what something actually means. And that's what they're really talking about here, as opposed to the technical meaning or the legal meaning or the current meaning. And so obviously we're starting to look at some of these other ways of reading the words in an act or the sections and how we might interpret it in a different way. And we also look at how do you interface with things. And I think, Carla, it might have been a question you asked last week. How do we do it? Do we look at it in terms of the act itself? I think we might have been looking at the idea of when do you look at the Acts Interpretation Act, or when do you look at the definition in another act and apply it to this act? And so that we're sort of taking a step further this week in looking at how we might interface with, say, a dictionary definition or the consistency of meaning across an entire act, because just part of an act might have a definition and then another part might have another definition, etc. And how different words used in different places in the act might have the same meaning, for example. So, I mean, obviously we're continuing our stepping stone through all of the different aids and mechanisms for interpretation, and we're focusing this week again on intrinsic things, the words within an act, rather than the things we were looking at in the first part of the course, which was extrinsic material, stuff outside the act that helps us to work out what's in the act. So in terms of some key words or key terms as they are described, the first one is composite. This idea that, they look at it in a chemistry sense here, a compound created of at least two elements different from each other. So that's quite a chemistry-like definition, a compound. But really, in a legal sense, it's the idea that there might be a phrase that's made up of various parts. And when do we need to look at that phrase as a whole with a number of words, or do we separate those words into individual elements? And if you look at it, that's what the chemistry definition says. It says a compound might be a number of molecules or chemical molecules put together, O2 or H2O or H2SO4 or whatever, all those different things we learn at school. In a legal sense, there might be a phrase, and that phrase might have individual words in it. Do we need to look at the phrase as a whole, or are we just looking at the individual words, and do we try to interpret the words first before we interpret the phrase? And you can see how that might change the meaning. If we look at the individual words, this word might have a meaning, that word might have a meaning, that word might have a meaning. And when we try to put them together by looking at them individually, it might change the meaning of the whole. But if we look at it as a phrase and define the phrase, slightly different meaning. And we're going to return to that soon. The next one's connotation. A meaning implied in addition to the primary meaning. The sense in which a word is used. When I think of the connotation in terms of interpretation, I suppose I'm thinking about how you see a word, but because we see the word in a context, I don't know, what's an example? Maybe if you saw an animal in a field, in a rural setting, obviously the connotation there is that the animal might be grazing, the animal might be being used for a purpose, a primary industry purpose. If you see the animal in a backyard of a residential home, the animal might be a pet. So the connotation is completely different in those different contexts, even though it's the same animal. Might be exactly the same sheep in a rural context and the same sheep in a residential context. There's a different connotation attaching to the two. And the same thing can occur, obviously, with a specific word. The word might be, I don't know, organisation. Organisation in one context might have a completely different meaning to organisation in another context. Denotation, the specific literal meaning of the word. So there's that first use here in this chapter of that phrase that I mentioned before, the literal meaning. This idea of reading the word in a paper form and just saying, what does that word mean without reference to anything else, without reference to another section in the Act, another extrinsic document. What does the word mean to me as a reasonable person reading that word? The next one, having regard to a phrase commonly found in legislation requiring a decision maker, should be maker rather than making, to take into account a factor and give it weight as a fundamental element. So, is there a phrase that we see often? For example, often in a pleading, so a document where a party sets out their case, as opposed to a statute, a party will say the phrase, at all material times. Now that phrase has a meaning. When we read it, we see the phrase at all material times and we think, well, they're not talking about today. They're talking about the period of time where the facts in issue occurred. So a year ago, someone might have entered into a contract. At that material time, the person was resident in Australia. Something simple like that. The legal meaning of something, as opposed to the ordinary day-to-day meaning, there might be a legal understanding of it that all of us derive by virtue of the fact that we've potentially studied law or practiced law or been working in the legal profession, etc. Or maybe we're just members of the public who have a familiarity with the law because we're dealing with contracts or we're dealing with something legal all the time. And that meaning then might be very different to the meaning if we just walked out onto the street and showed it to someone who had no familiarity at all with the legal concepts. Protean words are words which have a variable meaning. Well, to be honest, if words didn't have a variable meaning, if all of these statutes were certain, why would we need lawyers? We certainly wouldn't need lawyers to interpret statutes. We wouldn't need judges to interpret statutes because they'd be so clear. And unfortunately, or fortunately, the English language is not a certain language. It's not a codification language whereby everything is so specific. think of how many examples there are. I mean, I always think of the difficulty for those who learn say, the law in English as a second language. Imagine words like, you hear the word miner. Well, is that the person who digs a hole under the ground and works in an underground environment with coal or copper or gold or bauxite or mine or lead, etc.? Or is that a person under the age of 18? There are so many words in the English language which have multiple meanings. And I think protean words is a phrase which describes that variability in the English language as much as the variability in statutory interpretation. A conjunction or conjunctive words, the first word that comes to my mind is the word and, which they mention here. The way there are link words that we use in language, which are therefore used in statutory interpretation, which link together different elements or different parts of a section. Disjunctive words create alternatives or options or possibilities. So something or something else or something else, as opposed to you must do this, 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 and this. And if you're doing this, 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 and this, and you must do them, well, then it would be and. So the two are the opposite. That is, conjunctive words create effectively the opposite effect of disjunctive words. So as we were saying a little bit earlier, last week we started our discussion of intrinsic material, and we're really continuing on this week. And I think it's one of the good weeks of the course from my point of view, in the sense that we've built a foundation last week about some of these key concepts, and we're starting to drill into the detail of it in terms of intrinsic materials this week. It goes without saying that all words have meaning, but there's a real danger. As I read this in preparing for this afternoon, I was thinking of the fact that often, and you might have experienced it as well, when you are tired, you might type an email or type something at work or work on something at work. And when you're tired and you look at it a couple of weeks later and you look back at it, there'll be a word or two missing in a sentence. The rest of the words will be there, but it's just a word will be left out. Your brain tells you the word is there, but by virtue of the way you've worked on it, you're so focused on the detail of it that sometimes you actually leave something out. With a statute, I think there's a danger for us as the reader, as the interpreter, to see what we want to see in that sense, to read the statute in a way that might leave certain words out of the statute. And you might only need to leave one word out, or to not interpret the section, without that word in it. And that word might be very powerful. If it's an and or an or, that might have a radical impact, for example, on the meaning of that section. The first thing courts will do is make sure they've got the right section. And this is something I've mentioned in past weeks. I've been sitting in the High Court where the counsel have been referring to the wrong statute. That is, at a specific point in time, the statute that was in force, that was enacted at that point, was different to the statute that they were looking at in terms of their argument to the court. So that's the first step. The second step, once you've got the right statute, is to then ensure that you read the applicable words completely. And that's what they're saying here in this paragraph. You need to make sure every provision is given meaning. The provisions aren't ignored, and that the words in a provision aren't ignored. The textbook refers to this Australian High Court decision, Project Blue Sky, and the Australian Broadcasting Authority. Now, we looked at that case briefly last week as well. A court construing a statutory provision must strive to give meaning to every word of the provision. And of course, if you don't give meaning to all the words, it's going to impact the meaning. One of the difficulties, I think, is not giving meaning to the words that are there. It's the question that we've looked at in past weeks of where the court is saying, should we be adding effectively words that are not there into the section? There's a presumption that Parliament intended each word and each phrase to be given meaning. The first step, and what I like about this week, is that we're starting to sort of look at it in a practical sense. What do you do practically? You get the right statute. What do you then do with the statute? And I think this is a good example of it. The first step is, and this is, I suppose this is because this is how I was taught this exact same subject when I first learned it. That is, the first step is to read the words, read all the words, and give them what you think should be their ordinary meaning or their literal meaning, their plain meaning. Always consider the ordinary meaning. What would a reasonable person on the street say that this means if you ask them? If they sat down and they read it, what would they say? Don't start by reading the second reading speech of the minister or the explanatory memoranda or another act on the same topic or the previous act or a journal article, etc., etc. Start with a simple reading of the words. Concentrating on the individual words doesn't mean taking the words out of context. It just means reading them as a whole, reading them naturally, reading them in an ordinary way, as anybody would read a novel or a biography on someone, etc., etc. The example they're giving here is this idea of a word like made. What does made mean? And we were looking at, I was just giving the example before of minor. I mean, obviously, there's different spellings of the word minor, but even amongst the different spellings, if you think about it, they can have different meanings. For example, if I say a minor, as in M-I-N-E-R, am I referring to someone who works, and I use the example of being underground? Does it include someone who works above ground? Does it include someone who works in a mining company? I work in Santos Place. Does it include people who work for a mining company in an administrative environment or in a management environment? If it's not administrative, you can see how you can create interpretive problems as well by trying to stretch the meaning of the words. Not to make a fortress out of the dictionary, so not to try to give each word a meaning based upon a dictionary definition, as opposed to, because of course in a dictionary you'll see multiple meanings to things, whereas when you read it to someone on the street, they will tend to have an initial one-off meaning for a phrase or a section. I think that's always the interesting thing. Well, I think one of the hardest things is that for us all as members of the profession, we tend to change even the way we think about things so that we can never actually determine what the ordinary meaning is. You only need to look at, the newspapers to see that people have, in wider society, have very different views of lawyers. And I think it's a challenge then to ensure that if you're trying to interpret something in an ordinary way, you do it in an ordinary way, in a plain way, as opposed to doing it in a technical or legal way. And I haven't done it, but I wonder whether it's the real benefit is to go to someone outside, someone who is reading it in a plain way, and to get them to read it and say, what does that mean? You try to do it, but I don't think in the end you can do it, because I think that for all of us, even the fact that we're working through this subject together, we're changing the way we're thinking about interpretation. And of course, we're immediately starting to think about things in a technical way or in a legal way, in a contract law sense. And if, I'm sure in your introduction to law studies and in your other subjects and in law studies and in law, professional activities you've done relating to the law in the past, you've started to give technical and legal meanings to things by virtue of your experiences and your learning, as we all do. And it changes the way we then read something in a plain or ordinary way. They refer to some tax cases. There's a 1932, that is, the textbook refers to some tax cases. They're both High Court decisions, Commonwealth Law Report decisions, a 1932 one and a 1996 one. Is a sponge a pastry? What is silver dye bleach reversal process? So, the court was being forced into interpretation of specific things. You might remember, I think it was 2 or 3 years ago, there was a case about whether breadsticks were bread or not. And it was because the GST, because there's no GST on food items, or certain food items, I should say, and bread is one of the items, if my recollection serves me correctly, to which there's no GST applied because it's a staple part of our diet. The manufacturers of the breadsticks were saying, well, the breadsticks are bread under the statutory definition of bread, and therefore we should not have GST, which would have been significant for them in the marketplace because of their ability to reduce their cost to the public purchasing the breadsticks. I can't recall what the outcome was, but I think what's significant there is that you're often trying to achieve a commercial outcome with a legal interpretation, and that was certainly the case here, and it looks to have been the case in these decisions, or was the case in these decisions. And so the courts do accept that there is a presumption in favour of a technical or a trade meaning in a tax or a revenue statute. So in something which is a technical statute, there will be a presumption that the interpretation should be a technical one as well. But as we know from past weeks, the key determinative in terms of the interpretation is the purpose. And what's the purpose in a taxation statute, a revenue statute? Well, as they say up here, in a revenue statute, the primary purpose is to achieve revenue. So in 1932, when there was no purpose test, tax office, taxpayer, the court's trying to interpret the provision. Who are they going to favour? They're going to favour the taxpayer. In 1996, when there is a purpose test, tax office, taxpayer, they'll favour the tax office, because there the purpose is, at that point in time, is to achieve revenue for the Commonwealth. There's another more recent, not 2005 CLR decision, so 2005 volume 221, Commonwealth Law Report, so it's High Court, starts at page 249. The majority of the court used the technical meaning for the word pawned to arrive at a decision that the business was not a pawnbroker. Justice Kirby thought that using the strict legal meaning could only assist those who used devices to circumvent the operation of the 1996 Act in frustration of the important social purposes. So what was he saying? He was saying, you're trying to argue an interpretation which does not achieve the purpose, the primary purpose of the piece of legislation. You're trying to circumvent the legislation, and you're arguing something, or you're arguing a statutory purpose. You're arguing a statutory meaning contrary to that purpose because it suits you commercially. And that's a key sort of statement, and I think it's something that's not just key for this week, it's a key thing for the whole course. The current meaning of words. So this is a challenge because, of course, statutes can be very old. You look at a statute like the Partnership Act, 1891 in Queensland, they're very old statutes. They might have been changed over time, but when we are interpreting the statute, do we need to interpret the words in that statute as if they were written today or as if they were written in 1891? Very difficult to find out the meaning of the words as they were in 1891. I recall I had a case which involved a statute in a succession law matter, and I was for a beneficiary under a will, and her brother was an executor under the same will. He was also a beneficiary, but he was the executor. And what he and another executor had done is that the will was part of the estate. The fellow who had died, the father, was a very wealthy fellow. He had owned a number of large hotels. And what the executor and the other executor had done is they had valued the hotels, determined the value, paid the beneficiaries a sum of money, or based upon these valuations they'd done of these hotels, and they needed to get the court to confirm what they had done because they couldn't do it without the court's permission, sanction of what they were doing. The beneficiaries, most of them, the other children, had said, look, I don't have a problem with this. So that was going to make it relatively easy. But my beneficiary had said, look, it looks all right, but there might be a problem here. And can you have a look at it? And obviously they instructed lawyers who instructed me. Under that relevant will and under the relevant legislation in that jurisdiction, and it wasn't in Queensland, it said, in terms of the responsibilities of executors, if this act doesn't tell us the responsibilities, then you need to look to the position of an executor as it existed in England in 1871 or 1874 or something like that. So I had to find some books on the powers or otherwise of executors as at that time. So when I was reading this, I was thinking about just how difficult it would be if you were trying to interpret legislation as it existed in the past by virtue of a person reading that legislation at that time in the past. And it's very difficult. So courts, of course, have tended to give statutes their ordinary and current meaning, focused upon the meaning as at today, not the meaning that Parliament might have intended 100 years ago, 120 years ago, 20, 30, 40 years ago. And so they've taken into account, when they've interpreted things, the fact that computers have come in, the internet, all of these things that we didn't have, etc., even 15 years ago. There's another quote from Justice Kirby in a case called Coleman and Power. The purpose postulated in that meaning is an objective one, derived from the living language of the law. So he's talking about the law and the language of the law being interpreted in a way that takes into account today's thoughts and not thoughts in the past. There's another tax case mentioned there, Deputy Commissioner of Taxation and Clerk. This time, though, unusually, it's a New South Wales Court of Appeal decision from 2003. They were looking at the meaning of the word gas in terms of LPG gas, liquefied petroleum gas, as opposed to coal seam gas, etc., or coal gas. And they were looking at the relevant New South Wales legislation. They had to look at obviously, they tend to look at the previous cases that might have interpreted similar points. It's interesting that they mention mining operations here, because I had to look at that phrase the other night myself in a tax case that I'm doing, because the question is, what is a mining operation or a mining business in the case I'm in? And so, does it include research, for example? Is a mining operation when you're digging a hole in the ground? Or is a mining operation research about where you might next dig a new mine or open a new mine? Does it include your wharf facilities or your rail facilities or your investment facilities relating to your mine, etc.? All right, so dictionary meanings, and we started to look at this last week, but obviously there are a number of dictionaries that are often cited in judgments. They mention here the Concise Oxford Dictionary, but obviously people often have recourse to the Oxford English Dictionary, the big one, which is now most commonly found online. I haven't seen a paper version of it for many years. And a lot of people use the Macquarie Dictionary. I'm just looking at the different legal dictionaries, for example, that I use regularly. Mosley and Whiteley's, which is this one. Osborne's. Those two are both English legal dictionaries. This is the Oxford Australian Law Dictionary, which is in its second edition. It's only been out for the last 2 or 3 years. It's quite good. It's not what I don't like, or one of the things I think the Oxford Australian Law Dictionary doesn't do is it doesn't give case references to specific points. So you might get, for example, a definition of disbursements, out-of-pocket expenses incurred in performing work, contrast remuneration for work performed. That's the definition. Whereas if you go to Osborne's, it may not have a definition for disbursements. Which it doesn't. But what Osborne's does do generally is that if it gives a definition, it'll give a case reference for it. And so, or even a statutory reference. So if it mentions, say, disclaimer, it'll mention section 156 of the Property Law Act. And so those, I should say, though, they are technical and legal dictionaries as opposed to general dictionaries. That is Australian dictionaries and English dictionaries for common meaning or plain ordinary meaning of words. So it's important, I think, at times to refer to both. Remember that in certain statutes, and we were looking at the tax legislation before, you're entitled to use the technical and legal meaning there, whereas in some other statutes you'd be best to use just the ordinary and plain literal meaning, which you would get out of a normal concise Oxford or Oxford English Dictionary or etc. As to consistent meaning, often within a piece of legislation, there will be a word that is used often. Let's use the tax example again. A word like assessment might be used hundreds and hundreds of times in a piece of legislation. Now, unless you're told something to the contrary in the Act, you would normally give that word the same meaning throughout the Act. No matter how many times it is used, you give it a consistent meaning, unless you're told something to the contrary. And And that's particularly powerful because when you are giving something a consistent meaning, then it becomes particularly important if they use an alternative meaning. I was asked to give some advice just last week on the meaning of state, capital S state, which was used in a new act. And the question was whether a cabinet decision, once again, not in the state of Queensland, so we don't have to worry about Queensland, but the question was, the new Amendment Act used the word state, and it also used a reference to Executive Council. And the question was whether a decision of the Executive Council was, for the purposes of this Act, a decision of the state. And that required a very careful interpretation of what state meant and what those words Executive Council meant. And what was particularly telling was that in some sections they used the word state, and in other sections they used this phrase Executive Council, which was a clear indicator that there was an intention on the part of the legislature to differentiate the two. The next heading is variance of words, where a word or phrase is given a particular meaning. Other grammatical forms of the same word or phrase will have potentially corresponding meanings. Now, you see this often, like whenever you see a contract for the sale of land or a deed, often in the interpretation clauses or interpretation provisions, they'll say where you see a reference to male, it means males. Or where you see a reference to female, it also means females. Here, they refer to the Commonwealth Acts Interpretation Act, Section 18, capital A. In any act where a word or phrase is given a particular meaning, other parts of speech and grammatical forms of that word or phrase will have the corresponding meanings. So the plural or the adjective as opposed to the noun, etc., will have exactly the same meaning potentially, depending on the grammatical usage of the words. So that's quite it's extraordinary how powerful some of these sections in the Acts Interpretation Act can be. Limiting words is the next one. So sometimes there'll be limiting words. It's interesting here that I can't recall us having any Latin phrases put to us in these different modules before. So this is really the first one. De minimis non curat lex, meaning that the law is not concerned with trifling matters. So, I mean, it's rare to see the Latin phrases now used as much as they may have been used in the past. It's not that long ago that to get a law degree you had to, or certainly to get an arts degree, you had to do a language, and most people did Latin. And it wasn't that long ago that to get a law degree you had to do Latin as a subject. Or maybe it was a long time ago, but maybe I'm just showing my age. But certainly in my parents' generation that was the case. And through school, most people did either Latin and or French as languages. So this phrase says that minor variations may be permitted. And they refer to this case of Amica Proprietary Limited and Ellis, a 2010 High Court decision. The case was about the definition of this phrase, more probable than not. And it was a question, what do those words mean when you're talking about the deceased dying of mesothelioma, asbestosis, I suppose is my understanding of that word, as opposed to just lung cancer from smoking. So did the individual die more probably than not, or was it more probable than not that it was asbestosis or something in that realm, mesothelioma, as opposed to a cancer or some type of illness caused just by smoking cigarettes. And the court decided only matters which are de minimis, that is, not trifling matters, will usually be disregarded in the face of limiting words. So what are they really saying? They're saying you've got to interpret a phrase like that quite solely, primarily and exclusively by reference to the words in that phrase. They are limiting words, more probable than not. It's like reasonable balance of probabilities. It's sort of like another way of saying that. But it's very airy-fairy, to use the slang. It doesn't say a lot, does it? More probable than not. There are no simple answers to a definition like that, because in the end, the court's going to be focused very much upon the factual and expert evidence. They would have had medical evidence, and they would have been told, well, look, the medical evidence is that if you're exposed to asbestos, for example, 30 years ago, if you're working in the industry, you might have also smoked cigarettes, but there's the statistics say that the cause of mesothelioma in most people who both smoked and who were exposed is the exposure as opposed to the whatever, and there'll be a probability created. The court would have heard that evidence and would have had to make a decision on that. And you have to wonder whether, obviously, some of those factual things and the circumstances of the individuals are swaying at different points in time the interpretation that the court will give to a set of words. I always think of the case of Northern Sandblasting and Harris. It's a case that went to the High Court of Australia, if my recollection serves me correct, in 1992. My recollection is that it involved a little girl who suffered a brain injury as a result of faulty wiring at a house in Townsville, from recollection. And what had happened was that the electrician had gone to the house on behalf of the owner of the house. The electrician wasn't employed by the owner. The electrician was an independent contractor, from recollection, had gone to the house to fix the stove. And as part of that process, had wired the stove in a way that when the tap at the rear of the house, proximate to the kitchen, was touched, the little girl was electrocuted and suffered this brain injury. The matter went to the High Court about, well, what's the responsibility that the owners of the house might have when they ask an electrician to go around to the house? And the court said, well, the owners are responsible. There is liability in those circumstances. And I think it's an example of what I was just saying before, that sometimes you think, understandably, the court may be swayed by the factual circumstances in the way that it interprets the meaning of specific words. Words like more probable than not. Hendiadys. It's described in the Oxford Dictionary as the expression of a complex idea by two words usually connected with and. For example, gold and goblets. Gold and goblets. Well, see, I read those two phrases and I think they're completely separate things. Gold and goblets, to me, says that there might be some gold and some goblets. I think of the Indiana Jones movie with the chalice, or the goblet-looking chalice, shaped so that you can drink out of it. When I think of a golden goblet, though, I think of a gold chalice or a goblet made out of gold. So even in reading those two things, they say gold and goblets equals golden goblets. I don't see them as being the same thing. I see them as being potentially something different. And maybe that's very dangerous because maybe I'm interpreting those words in a technical or legal or non-literal way. And so the challenge for the court is to determine whether the words are to be read together or separately. And your textbook gives an example of this phrase, symptoms and disability. And you can see by the name of the case they refer to, Victims Compensation Fund Corporation and Brown, that the High Court determined that the phrase meant the person needed to have both the symptoms and a disability. So that's reading the words conjunctively, reading them together, saying you need to have both this and this. And that's quite understandable because there's the and straight in the middle. And is a conjunctive word. Temporal expressions. Here the challenge is for the court to determine if it is a requirement that something happens in the future, the past, or the present. All right, so let's have a look at the example. Will, did, will and could, future. Did and was, past, is present. So that's just the grammatical meaning that we know from the plain understanding of words. The case example is from the New South Wales Court of Appeal. Any dependent of the person who will forfeit an interest in property. So it's future. Will forfeit indicates a future tense. So you need to have something happen from this point. So the act comes into force. Okay, let's look forwards from that point in time. It's not retrospective. Unless the act says it's retrospective, we would imply that it's not retrospective or interpret it as not being retrospective. Although, in the alternative, the Court of Appeal preferred an interpretation of the section which it thought promoted the purposes of the act. It found that giving the provision a literal interpretation did not favour the purpose, which was to relieve dependents from hardship caused by forfeiture. So what they were saying was look, the purpose of the act was for it to impact upon people who had already, the past, had already suffered these or had these set of circumstances applied to them. And then there's a second case, Jamina Gasworks New South Wales Limited and the Mines Subsidence Board, which went to the High Court in 2011. In that case, they required the claimant to wait until destruction had occurred before taking remedial work, or the requirement. And they said that would be irrational because to apply only a future tense would be irrational. It wasn't the purpose of the act. So part of that is to look at the tense of the words, but also, importantly, and both of these cases are an example of it, this one and this one, both cases are an example of where the purpose overrides the tense. Common words and expressions, they appear regularly, and usually where they appear regularly, you're either going to look for them in the Acts Interpretation Act. They might be defined in the individual act. Then you look at the Acts Interpretation Act, and then you look generally to see whether they're defined elsewhere. Deemed is the first one they give an example of. For the purposes of the legislation, something is deemed to be the case without any further proof or evidence. They refer to the Drugs Misuse Act. Person who attempts to commit a crime is deemed to be guilty of the intended crime and is liable to the same punishment and forfeiture as a person who commits the intended crime. So it's as if, by virtue of the word deemed, that you did the offence even if you didn't do the offence. What's the example of that? They find your utility vehicle, your ute. In the back of your ute are tools to open a safe, tools to open a building, computer technology that allows you to disarm an alarm system on a property, a plan of a house, an identification of specific jewellery or something. The police arrest you at the front of the house. There's a range of indicators there, clear indicators, that you were probably intending to rob or burgle that house. You would be potentially charged with, you might be deemed to have committed the crime by virtue of the fact that you were intending to commit the offence. I'm just making that example up, but I'm trying to give you an example practically of how this word deemed might be used. Have regard to is another phrase. You see it obviously in administrative law around what should a good decision maker do, what will be the steps they'll need to take before they can make a decision. For example, in planning law, and a decision maker needed to take into account planning policies and environmental impact statements and all types of documents. And if they didn't take one of those documents into account, their decision would not be a good decision in administrative law. It wouldn't be a correct decision. Used, they use that word protean, which means, quite simply, used can have a number of meanings, variable meanings, depending on the circumstances of the case. Could be used, or could be interpreted, I should say, broadly or narrowly, widely or narrowly. Import, it's also protean quality. I had a case I might have mentioned to you earlier in the semester. I had a case which was about counterfeit cigarettes. It was nothing to do with, I wasn't doing anything to do with the criminal side of it, but I was doing it in the sense that the cigarette company were wanting to bring a trademarks intellectual property case against the supermarket chain that were distributing the cigarettes. Now, of course, the supermarket chain's position was they didn't even know they were cigarettes. They were so similar to the real cigarettes without the little digital codes and wrapping on the packaging that identify them as real. To a normal human being, you couldn't tell. And I recall that the word import was a relevant word in that case, as one of the words we had to interpret and work out what does it mean to import in those circumstances. And they give two criminal cases here as examples from the textbook. The last one is publish, a word with a definition often used in defamation cases. That is where I publish something. Let's say I type an email or put something on a blog, or I would never do such a thing, but someone might do it, that defames someone. And that idea of publication then, or to publish, becomes very important in a defamation case or in some type of tortious case. That is a case about money or loss involving the publication of something. And once again, they give a federal court decision there. ACCC, the Australian Competition and Consumer Commission, and Allergy. And so you can see that's not a defamation case as such. That's a case about something that was done by this company in terms of future uses of Facebook and social media. So we've looked at the interpretation of legislation. We've looked at some specific words and ordinary meanings, and we've started to try to work out, well, in a practical sense, what I do like about this week, as I said earlier, in a practical sense, we've started to look at the specific mechanisms in a practical way by which we interpret different legislation.